Hello, how are you, friends? Welcome to Children of Darkness and Light, where we talk about all things Vallow and Daybell. For those of you who are new to our channel, my name is Lori Hellis. I'm your host. I'm a retired criminal attorney and an author. I'm writing a book about the Daybell case, and fortunately have a very patient publisher who is willing to wait until the trial is over and I can write the full story. So I have a few things I want to talk about before we dive into the case in general. First of all, I want you to know that our moderators tonight, Michelle and the ever popular brown-eyed girl, are here to keep track of the chat for me. Michelle is going to be posting questions later in the show, so be sure if you have questions for me that you post those in the chat, and she'll be putting them up for me to take a look at a little bit later. She's going to be posting and answering questions, so if you see her come up as Children of Darkness and Light, she's our moderator for the evening, along with Brenda, brown-eyed girl. And I wanted to talk just a little bit. We've had some requests for to know whether or not we were accepting donations or super chats. And when you start a new channel, it takes a little bit to get the monetization set up. And I decided that I would do that because I would welcome any of you making donations to go towards our moderators. So on this channel, any super chats that come in will go directly to the moderators for that night. I also wanted to let everybody know wristbands are available if you're new to the channel. These are wristbands that say justice for Tylee and JJ. They're available free of charge. All you have to do is send me a self-addressed stamped envelope, so you pay for the postage, and we'll get them out to you. I'll ask the moderators to post the address in the show notes and also in the comments. I also want to say some of you discovered that there was a video that came on live kind of in the middle of the night in the US. And it was a mistake on my part. I'm still trying to learn all this technology. And so I thought that I had posted it so I could do a final edit on it, and instead it posted live. It was a very choppy introduction to the case, and so forgive me for that. I've taken it down for now until we can get it completely edited, and then I will put it back up. It's an introduction to the Daybell case for people who might not be as familiar with all the players, because there are a lot of people involved in this case. So hopefully we'll get that back up shortly. I did have a bit of news to share that is unrelated to Daybell. For those of you who in our true crime community who follow other cases, you're familiar with the Delphi murder case. This was two young girls in, I always want to say Illinois, but I think it was Indiana. And they went to a park one day and they disappeared. They were Libby German and Abby Williams. And their bodies were found in the park, and they were, and that was 5 years ago. It's been a long investigation. There's been a person of interest who was a person who had chatted with one of the girls online and had a history of being involved in some untoward activities having to do with kids and online presence. And I'm trying to be a little bit delicate because YouTube doesn't like us to mention certain subjects. So, but interestingly enough, they made an arrest today in that case. It was not the person who was a person of interest. And but the most interesting part about it is that the tip came in to a YouTube podcast called Murder Street, and they passed the tip on to law enforcement, and the tip was good. and they've made an arrest based on it. So if you all think that this community doesn't do any good and we're all just hanging around for the salacious bits of it, you can pat yourselves on the back, because it was in fact a tip that came into a YouTube channel that has, it appears, broken the case. So there were some things that happened in the Daybell case and Vallow cases this week, and so I want to talk a little bit about them. Not anything earth-shattering, but a couple of things that are sort of gee whiz moments. There was a spattering of filings that happened earlier in the week, and they've all been sealed because they appear to have something to do with Lori's mental health evaluations. Probably the most interesting one is that the state, the prosecutor, filed a motion bringing up an issue of conflict in a case, and the caption says, as it has to do with Dr. Wellner, Welner. And Dr. Wellner is a very well-known forensic psychiatrist, not a forensic psychologist. And he is the forensic psychiatrist who did the evaluation on Brian David Mitchell, who was Elizabeth Smart's kidnapper, and finally reported to the court that he was not incompetent, that he was actually malingering. And so it's kind of interesting that his name has come up in this case. And it's interesting that it appears that the defense has brought his name up. That's surprising. Surprising because you would think that a forensic specialist who specializes in proving people are malingering wouldn't be a person the defense would be looking for, unless they are really taking the position that they want somebody who is really who is all in on malingering, is a person who they want to come in and evaluate Lori, because if he says she's not malingering, then maybe he's kind of the expert on that. It'll be interesting to see how that shakes out. Unfortunately, because it does deal with Lori's mental health, we're going to see a lot of sealed documents around that issue. We should be able to know whether or not Dr. Wellner is going to be involved, because that's something that's already come out in the documents. But as to the extent of his involvement or what any kind of evaluation might show, that isn't something we'll get any information about anytime soon. So one thing I wanted to do tonight, I've had a lot of questions about marital privilege and the idea of why Lori and Chad are not, why Chad's not divorcing Lori. So I wanted to talk about that. But before I do, I have to tell you, I have to share this with you because it absolutely gave me the biggest chuckle all day today. I'm a meme. Look at that. You probably have seen these memes going around. It's some sort of a template that looks like a Halloween costume, and I was thrilled to discover that I am now my own meme. So that was great fun today. I feel like I've finally arrived in the world now that I have my own meme. Oh, Claire, good question. And we're going to talk about marital privilege. Marital privilege is kind of a funny animal, and that is a really good question. Whether or not the privilege continues to, the privilege applies to things and conversations that happen prior to the marriage. So let's talk a little bit first about privilege, marital privilege, and what happens. There is a privilege, and Idaho has this law as well, that says that a husband and wife cannot be compelled to testify against one another. Either of the spouses can invoke the privilege, and either one of the spouses can waive the privilege. So, for example, in a case such as Chad and Lori's, either one of them, Lori could say, I am going to choose to testify about my communication with Chad, and I'm going to waive the marital privilege. Now, I didn't have a chance today to get into the case law, so there may be some finer points to that that I wasn't able to get to today. But there's a couple of important exceptions to the marital privilege. First of all, it has to have happened during the marriage. Second, it has there are exceptions that don't allow spouses to claim the marital privilege if the issue at hand has to do with a crime committed against the other spouse, or has to do with injury or a crime being committed against either spouse's children. Sorry, I was having trouble getting that out. So in either case, the exception, the privilege doesn't apply, and they can't invoke that privilege. So if this were a case where one person had assaulted the other one, there wouldn't be any marital privilege that would protect either one of them in a criminal case. And in this case, because it has to do with the children of one of the spouses, that marital privilege doesn't apply. So it applies to communication that happens during the marriage, and it applies to that communication between the spouses. So where I think this possibly comes in is as it has to do with Tammy Daybell's death. Now, we know that the children and Tammy were all three murdered prior to Chad and Lori being married. So Chad and Lori weren't married until November 5th of 2019. So we know that the crimes predated their marriage, but any communication between them about the crimes could be privileged, except that anything having to do with the children's deaths would not be privileged because of the exception. Where it does potentially come in may be surrounding Tammy's death. Now, we don't know because we have seen what everyone tells us is a very small portion of all of the evidence against these two. We haven't seen anything, we haven't seen any of the text messages and the communication that may have gone back and forth between them after November 5th. So if there's text traffic back and forth that might incriminate either one of them, there would be the potential for them to invoke the marital privilege as it applies to anything incriminating them in Tammy's death. Hopefully that makes sense. So they wouldn't be able to invoke that in the children's deaths, but they would be able to in Tammy's death. So although they can't say our communication prior to November 5th of 2019 is privileged because they weren't married, there is a certain amount of look back to that. So conversations that they had in the after the marriage, they could say, well, we talked about that event even after our marriage, and so that portion of it could be privileged. So a lot of people have asked, why doesn't Chad just divorce Lori? That may be the case. That may be the reason why. I don't know that he's in a huge rush to take any radical steps, but it's clear that he and his lawyer are taking the position that that Chad was an innocent bystander, that Lori and her brother Alex were the movers in the case, and that they were the actors, and that there is good question. And so Chad's taking the position that it was all Lori and Alex, and that he was an innocent bystander. Lee here asks the question, does their sealing together in the temple have any legal validity? The answer is no. So it's a little bit different. Let's remember that Lori and Chad, as early as September of 2018, there's a lot of discussion about when this actually happened, but as early as September of 2018, they met in St. George, Utah at a Preparing the People event. They went to the temple together and secretly sealed themselves to one another. Lori and Chad both had legal spouses who they had been sealed to in the temple. So there was no question of them actually officially being sealed in a church-sanctioned ceremony. They claimed that they got together possibly with one other person, that the angel Moroni and Jesus were there in person and sanctified their sealing, and that they sealed themselves to one another. It was in no way a legal, official LDS temple sanctioned marriage. When people are married in the temple, that by an LDS officiant, that officiant can sign their marriage license and they can be legally married it is recognized as a legal marriage. That was not the case with what happened with Chad and Lori. Chad and Lori had gone through those official temple ceremonies with their respective spouses. Chad and Tammy were married in the Manti Temple. Lori and Charles, I believe, were married in the Mesa Temple. So, but they were actually in LDS sanctioned, officiated by an LDS officiant who was legally able to sign their documents in the state that they got married in. So they're two vastly different things. The ceremony that Lori and Chad had absolutely was not valid, but they did get legally married. We saw their marriage certificate was produced during Chad's preliminary hearing. They did get legally married in Hawaii. So those are great questions. So I'm happy to answer questions. I'm sure Michelle started to put them up, and we'll chat about what comes next. I don't really plan to talk a lot about other cases, although, when big developments happen in some of the cases that our community are also following, it's great to put those up, like the announcement about the arrest in the Delphi case. Michelle asks, do both sides know all the evidence against Chad and Lori? Absolutely. It is a constitutional requirement that the state give every shred of evidence to the defense. And so at the last hearing, we had a little bit of a John Pryor meltdown over the states not being able to produce all of the DNA evidence. So you might remember that there has been this small amount of DNA material that was found on tools in Chad's shed, and that there's such a small amount that there was a concern that the sample would have to be consumed in order to do the DNA testing. So they went back and forth about whether or not they were going to agree to this consumptive testing. Ultimately, they came up with an agreement about how to handle those samples. And the prosecution sent them off to the state crime lab to be processed. One of the issues that came up in the last hearing was the fact that the defense has still not gotten the results from that. And there was an interesting little twist because Lindsay Blake, who is the Fremont County prosecutor, said, well, we can resolve this because if the evidence doesn't come back, we just won't offer it. And John Pryor just about popped an artery in his brain, and rightly so, because the district attorney is required to present and provide all evidence, because what would happen if that evidence turned out to be exculpatory? What happened if somehow that evidence absolutely exonerated Chad Daybell? Well, John Pryor is entitled to get all of that evidence, and the major constitutional cases having to do with the turning over of evidence of the discovery process is about the DA having an obligation to provide all evidence, even evidence that proves that the defendant didn't do the crime. Any exculpatory evidence has to be provided. So John Pryor was correct that it isn't a decision that the prosecutor gets to make about whether or not they're going to offer the evidence. That is purely their choice, but they don't get to choose whether or not they give the evidence to John Pryor. So the other development that happened just a little while before we hit the air was that Judge Boyce granted Chad Daybell's continuance. A new date hasn't been set yet for either Chad or Lori. Lori, of course, hers is stayed. So we don't have a new date yet, but the court did right at 5 o'clock on Friday announce that his motion had been granted. How long can this go on? How long can they stay the trial? Suzanne, that's a great question. And the answer is pretty long. If you remember in the Elizabeth Smart kidnapping case, her kidnappers were both initially ruled to be incompetent. As we were just talking about, Brian David Mitchell eventually was proven to be malingering, but his wife, Wanda Barzy, was incompetent, and she remained incompetent, and that case remained stayed for 8 years. And then ultimately, at the end of that, she was restored to competence and tried and convicted. So the issue of competency is not a short-term issue. I think in Lori's case, we're going to see much less. We're going to see a quicker turnaround this time. The reason I say that is because she's already had evaluations at the state hospital. They already know her diagnosis. They've already been working with her on medication. There already is a court order saying that she has to take medication. So there's no chance that there's going to be a delay for that. So I think we're going to see a much shorter period of time before she's restored back to competence. So, but these cases take a long time, and death penalty cases, they're excruciatingly slow because nobody wants to make a mistake and end up sending someone to death row that doesn't belong there. Good question. How does moving Chad's trial out and not separating the trials affect Chad's right to a speedy trial? Happy Friday, by the way. So there's a couple of places where speedy trial is an issue. First of all, every state says if a person is in custody, there is a fixed amount of time before that person has to be tried unless they waive their right to a speedy trial. So in Idaho, that period is 6 months, and Chad, in fact, did waive his speedy trial rights some time ago, while Lori was at the state hospital the first time. So Chad understands that that 6-month time frame no longer applies. But the federal Supreme Court has said that failure to bring someone to trial in a reasonable manner violates their speedy trial rights. And in those cases, it has been somewhere around the 3-year mark where the Supreme Court has said, this is just taking too long and this person is being held charged with a crime he's presumed innocent of for a too long a period of time. So I would be very surprised to see the Idaho court bump up against those constitutional speedy trial issues. And I would not be surprised to see the court sever the cases and move forward with Chad's case. The more this goes on, the more argument there is for severance. So I missed that. Why? Okay. Michelle, can you put that question back up? Thanks. Why can't the court require the defendants post-stay and prosecution to complete any testing on the kids' remains and the remains released? That's a great question. And I know that it is so painful for Kay and Larry Woodcock. They were in Rexburg for the last series of hearings, and Larry once again was talking about the fact that he would like to lay the kids to rest. The court at this point does not have the power to say to the defense or the prosecution, get all your testing done because this is the only chance you're going to get. And the prosecution is being very overly cautious and saying we are not going to release the children's remains until the trial is over. No one really knows whether they will want to continue to hold the remains if there's appeals. That could depend on what issues come up at appeal. So it's agonizing for the families, and it's difficult for the prosecution, who I'm sure they would very much like to honor the request and return the children's remains. But, there's also the risk of the defense at the last minute saying we want to have a second autopsy, or we want to have these results confirmed by a different expert. And that could, if the remains were not available for testing, that could jeopardize the state's case. And so it's kind of a double-edged sword. I know that Larry and Kay understand it, but it still hurts their heart. Jen Chapman asks, what if Lori is restored from taking meds and realizes what she has done? Is she allowed time to integrate to protect her from psychological danger? This would be a great question for Dr. John Mathias. I'm not a psychologist. I think that regardless of the outcome of the trial, it's clear that she will need continuing mental health treatment. What that looks like if she's convicted is up to the state of Idaho as to the level of mental health treatment that they provide. I think I understand the case being that the question being that at this point, Lori has been able to really compartmentalize, and because of her delusions, been able to justify or compartmentalize what she's done. And if she were actually able to internalize and understand as a thinking person what she'd done, um, it may damage her psychologically. And I can't disagree with that. I think it is quite possible. I will say that T. Diva asked, couldn't she be treated in jail? She can be treated in jail to the extent that the treatment exists in prison. And every state is a little bit different in the kinds of services that they offer to inmates in prison. So there are some states where there's virtually no treatment in prison, whether it's drug, alcohol, pedophilia, there's no treatment. And then there are other states that tend to be more progressive and understand that rehabilitation is, to the extent that it's possible, is important to keep people from going back and committing more crimes. So to cut down on recidivism, there are a lot of prisons that are now offering those sorts of programs, treatment in the prison. But it varies from state to state as what might be available to her. And it's doubtful that there would be intensive mental health treatment for her in prison. I think she would be permitted to continue to take her medication. I think the prison likes people to take their medication because then they're not behavior problems and they're not, there aren't other problems with the inmates. But I'm not, it really varies from state to state as to what the extent to which they offer treatment. So. Is it fair to say that the second person to be tried, if the trials are separated, has an advantage? Absolutely. Absolutely. The defense and the prosecution both get to test their theories of the case on a jury. They both get to test the evidence and examine how the evidence plays out. They get to hear the witnesses in real time. And the witnesses have the opportunity to, I won't say practice, but the opportunity to give their testimony. And then, because it's only human nature, witnesses come to court, they're usually very nervous. They're usually, it's usually a very foreign environment to most people. They're not used to coming to court to testify. And it's kind of a nerve-wracking thing. The second time they do it, it's going to be easier. And the second time they do it, they're going to be able to have thought, how could I have said that better? Not necessarily change their stories, but just think about, well, I kind of stumbled over that and I probably could have described it better. I could have told that story better. And I think that it absolutely decidedly gives the second person an advantage. The other thing is that both defense and prosecution will have seen the evidence in trial and have had an opportunity to challenge evidence based on the rules of evidence, and the rulings from the court will be clear. They'll have an idea, okay, the judge ruled that could come in under an exception to the hearsay rule. This piece of evidence comes in. If the judge rules that way, you expect he's going to rule the same way in the next trial. So yeah, there are certainly advantages to being the second person in the second trial. Looks like our chat is really busy. I'm thrilled. I do want to I do want to chat a little bit about how amazing our response has been to the channel so far. We have Our analytics are remarkable. We met our goal. We met all of the requirements to be monetized the first week, which is unheard of. Because you have to have a certain amount of subscribers and a certain amount of viewer hours. We have had over 25,000 views total on the site since the first two lives went up the first 2 weeks. And we have almost 400 people in chat right now. So I want to thank all of you for supporting us, for supporting me and our moderators, and I'm really looking forward to talking with you every Friday and being able to continue to follow the case. You know, we talk a lot about the legal issues because that's sort of the thing that nobody else is talking about. When you tune into the other YouTube channels, the questions about the legal procedure and how the court process works are the piece that I can answer and that aren't being talked about other places. But please do ask other questions besides the legal questions, because we do want to be thorough and we do want to talk about other things besides that. Michelle, we've answered that question, so I'll take the next one. I want to say hi to Denise and Diane. They are two sisters who are two of a set of triplets, and Diane lives here in the Boise area, and Denise lives in California. Denise is a paralegal and has done, she's always sending me little tidbits and little pieces of research. And I had lunch today with Diane, so it was really a blast. And I'm excited because I've really gotten to know a lot of the folks that are in the Boise Meridian area. And it's a lot of fun. It's a great way to make some new friends. Melanie wants to know, have you heard back on your motion with the court? We have not. It's interesting. I don't think that Judge Boyce is in any real big hurry to release all that information. But I was told that he was on vacation this last week. So it may be that we didn't see any answers to any of the other motions until today at 5 o'clock. And we got the answer for the Chad's continuous. So I see Jan asking me, I see that coming up. Thank you, Jan, for the super chat. I will be at CrimeCon. For those of you who don't know what CrimeCon is, I didn't go till last year. Just like we have Comic Con and Sci-Fi Con and all that, well, there is a CrimeCon. And it is a convention of true crime people, people who are interested in true crime, people who are involved in the media and following the cases, prosecuting the cases. It's fascinating. And I went this last year, and this last year it was in April. And I had a blast. It was in Las Vegas. I got to meet in person a bunch of other creators who I'd only met online. And so I will be at CrimeCon in 2023. It's in Orlando, Florida this year in September, next year in September. I was hoping if we had a trial, if we had a trial in January, that we might even be doing some pre-orders for the book. But it doesn't look like that's going to happen, but I am going to be at CrimeCon. Somebody, thank you, Paula, for the super sticker. My mods, thank you very much for that. I appreciate it so much. It allows me to, it allows me to recognize our mods and do a little something to appreciate them. So, is there a difference in appeals for conviction of death versus life? Yes, definitely. There is a difference in appeals. The basis for appeals in a life without parole case are substantially less than in a death penalty case. So there are many, many more issues that could come up on appeal in a death penalty case. There is a whole body of law having to do with the constitutionality of the death penalty, the process that one has to go through in order to be convicted and sentenced. There's just many, many, many more hoops that have to be jumped through. And so that makes many, many more opportunities for there to be issues come up that could be appealed. So definitely much less. What we know, thank you, Debbie Biggs. Thank you for your chat for our mods. And thank you for appreciating the newsletter. I enjoy very much writing it. And I enjoy kind of digging into the in-depth stuff. I know that some people get really interested, like me. They're a little wonky and they like to get down in the weeds and go down all the rabbit holes. And then there are other people that are like, nah, not so much. So I try and do a little of both so that people who want to skip the stuff you need to be in the weeds for can. But I'm glad that you enjoy it. It's great fun, and I have met so many great people writing the newsletter. So Jennifer Huddleston, thank you for that question. I think that's a question that's sort of at the top of all of our minds. One of the really pointed things that John Pryor talked about in his motion to continue was the fact that he is a sole practitioner, that he is working the case on his own, that he has not been able to find co-counsel who are willing to take on the case. And so I think I think that he may be teeing up a request either for some help from the state or for getting Chad a public defender. What we know is, I mean, there's no question at this point, Chad's indigent. We know that he owned a home that he owned with Tammy. He signed the title to that property over to John Pryor in lieu of attorney fees. And that's not all that uncommon. Let me just say, that's not it. Liens on property, on real estate for attorney fees happen fairly frequently in these complex, high dollar kinds of cases. So it wasn't that unusual, but I did the math, and assuming that the net on the house was somewhere around $100,000, I would say that it's long gone. So the bigger issue, I'm sure, I mean, John Pryor can work for free if he wants, or work for that flat fee, but it's difficult because there's so much expense that comes with this sort of a case. There's experts, there's secondary testing, there's, talking to Dr. Wellner or Welter, the forensic psychiatrist. He's not talking to anybody for free. He's charging fees. I mean, any number of experts could be required, and that has to come out of somebody's pocket. And in this case, there's no pocket for it to come out of when it comes to Chad. So I don't know who's paying those expenses, and if they're just racking up, and what they think they're going to use to pay for that going forward. I do want to say that Idaho has a Slayer law, has a Son of Sam law, which says that a person cannot profit from their crime. Some of those laws have been called into question on First Amendment rights, but at this point, they have not been. The U.S. Supreme Court has not said they're unconstitutional. So that would preclude Chad from making any kind of money that he could pay his legal expenses with. So it does make me wonder if John Pryor's motion to continue is sort of teeing up the issue of Chad being indigent and needing a public defender. Do I think Chad and Lori's attorneys are preparing or talking now in case the trials are together? To a certain extent, they may be. I think that Jim Archibald may have a better relationship with John Pryor than Mark Means did, but I don't know. Typically, in a co-conspirator case, there's some conversations that happen between the lawyers. They do sort of talk about if the plan is to present a united defense, then the attorneys would be talking to one another about what their theory of the case was and the evidence that was going to support that. If, on the other hand, they're going to point fingers at one another, I don't think that's going to happen so much. And it's pretty clear from John Pryor's comments and motions that his intention is to point the finger at Lori and her brother Alex. So I doubt there's a lot of conversation going on right now, only because I think there's a lot of finger pointing. Good Lori, is it possible that John Pryor and Jim Archibald might plead Chad and Lori guilty to a lesser charge because of the mountain of evidence against them and to avoid the death penalty? If their clients had one iota of sense, they probably would. I can't say what kind of a deal's on the table. I cannot say what sort of an offer that Rob Wood has made to either one of them. He may very well have made some sort of an offer that is, we'll take death off the table, but in return, each of your clients has to be completely honest, has to be completely forthcoming, and answer all of our questions, because that's kind of a typical thing prosecutors do. I think if either one of them were going to take a plea, they would have done it already. I could be wrong. I mean, I've seen pleas right on the courthouse steps. I've seen people take pleas just before their lawyers walk in the courtroom. So it's not out of the question, but it seems to me that if either one of them were inclined to take a plea, they would have done so by now. And the prosecutor could very much offer to take the death penalty off the table, give them life in prison without the possibility of parole, and then be able to get a full description of what happened. Do I think Melanie Gibb and Zulema will be testifying against Lori, Chad, or both? I think they both will be testifying in both hearings. I don't know that they're as loyal as they used to be. As Scott Reich is said on one of his recent broadcasts, fear of incarceration makes people talk, and that is very true. He was talking about the Harmony Montgomery case and the fact that the stepmother has now come out and told everything about Harmony, and her father has now been arrested for her murder. So, and he was talking about it in terms of, if you're afraid you're going to go to jail for a long time, you might just talk. I think that's the case with Melanie and Zulema. We know Zulema has immunity. I suspect Melanie Gibb does as well. And I think they're both going to be testifying. I think we saw a real departure in both of their interviews with the Arizona police. I think we saw them backpedaling quite a bit on how much they believed and how much they were faithful to the cause. And so we know Zulema has immunity. We know that from the recorded conversation Rob Wood had with her and with her lawyer. What the extent of that agreement is, it's a little hard to say. But in general, what the prosecution agrees to is that any information that the person admits that might incriminate them in this particular case and crime would not be prosecuted. So, for example, if Zulema could be considered an accessory after the fact because she knew that that Alex had killed the children, then she couldn't be prosecuted as an accessory after the fact because the immunity agreement would protect her. But immunity agreements are not a get out of jail free card for the rest of your life. They're very specific to this case and to what it is that she's testifying to that could potentially incriminate her as well. So they're asking her to waive her Fifth Amendment right not to incriminate herself in return for them saying, we won't prosecute you. So hopefully that makes sense. Oh, good question. If Chad is convicted for Tammy's murder, will he have to give the insurance money back? So let's talk about that. First of all, I think it's all gone. It's been spent. Between lawyers and it's all gone. But could he be liable to repay that? So it is the difference between a civil matter and a criminal matter. In the criminal matter, he could be required to make restitution to the insurance company. So that is a possibility. But the insurance company could also bring a civil suit against Chad to get a judgment against him to recover the insurance money. Either way, it's an empty judgment because he doesn't have anything. And because of the Son of Sam and Slayer laws, the insurance company couldn't say, if you ever write a book or you ever profit in any way from this, we get the money, because that's against the law in Idaho. So it's a really interesting idea. The problem is there's no money. There's nothing to pay anybody back. And, it will be interesting. Would the delayed trial also delay others getting charged if they're witnesses? Yeah, because they would only be charged if they didn't go and testify truthfully and fulfill their agreement, whatever their agreement is with the prosecution. I'm suspicious that Melanie Boudreau-Pulowski has a deal because she had those charges that were filed and then really quickly dropped. They were identity fraud charges having to do with her taking money out of Brandon Boudreau's bank account after the divorce was final and she was supposed to have removed herself off the account. So I suspect that that was one of those deals where they said, if you go and testify truthfully, we won't refile those charges. So that is possible. And there are, I think, other potential charges that could be filed. Oh, let's see. It's a red blend, and it's called, tonight's red blend is called Figment, Pigment, Figment. I'm a fan of red blends, so that's what's in my glass tonight. How long can the joint trial be postponed when one defendant may or may not have mental health issues? So I think that is a great question, and I think that it's a legal question that I think the judge is teeing up. You might remember in the last hearing, the prosecution came right out of the gate and said, we're going to make a motion that Chad Daybell's case be stayed along with Lori Vallow. Since they're co-defendants and their trials are joined, we want his case stayed too. And the judge said, there's no legal basis for that. I don't have authority to do that. He's not mentally incompetent, and I'm not going to stay his case. That was the right decision. Legally, he didn't have the authority to stay Chad's case because of Lori's mental health. But it also sort of telegraphs that the judge understands that he can't delay Chad's case indefinitely because of Lori's mental health. That was a question that came up last time Lori was incompetent, but I don't think there was quite a sense of urgency that there is now, because that was a year ago. So now a year's passed, it's feeling a little bit more urgent to get this case to trial. And there seem to be some pretty compelling reasons to sever the cases. Now, you might remember a year or so ago when John Pryor initially filed a motion to sever the cases. That was a very generic, very vanilla, very just sort of pro forma motion. It was a couple of pages long, and it basically said it would be unfair, and that was the end of it. This last motion to sever was a very robust argument about all of the issues, why it would be unfair for Chad and Lori to be tried together. And I think that John Pryor made some very cogent arguments, and I have to agree that I think the reason you sever cases is because it's a catch-22. You can't, if you happen to be my age, you know what that means. It's a circular argument, because you can't offer a full-throated defense for Chad and not compromise or prejudice Lori's case, and vice versa. So I think it is really much more likely at this point that we're going to see the cases severed. And I think that we are going to see I think we're going to, not only are we going to see the cases severed, but I think we're going to see Chad's case be scheduled for trial and go forward. Joe Pa, do I think the defense attorneys are chomping at the bit to cross-examine Zulema and Melanie Gibb? You know, Zulema, I don't know, because we haven't heard her testify before, but I'm certain that they are chomping at the bit to cross-examine Melanie Gibb, particularly since that recorded phone call with Sherry Dowdle came out, where Melanie was directly talking about the fact that people who become zombies disappear, and the children are both zombies. So, you know, I think there are going to be a lot of people who are going to be really interested in what Melanie Gibb has to say, and in cross-examining her. Yeah. Wow, we have almost 500 people on the live stream right now. Thank you so much for joining us tonight, and thanks for everybody who's subscribed. Please like and subscribe because it does help the channel. I'm absolutely like mind blown by the response so far, and I can't tell you how much I appreciate it, and how much I enjoy getting the chance to visit with all of you and to chat with all of you. I figured out a long time ago that if I watch the comments, I don't make sense. So I try not to do that, but I want you all to know that I do go back. I will go back tomorrow and I will read every comment. I will read every comment in chat. I will read every one of the comments y'all post below, and I try and answer as many of them as I can. But I mean, we've had somewhere around 2,500 comments in the last two lives. So thank you, Double Rainbows. You all are amazing, because I wouldn't be sitting here doing this if it weren't for you all being willing to tune in live and then catch it on the re-records. We have viewers who are following and subscribing from all over the English-speaking world, from South Africa, from Australia, from New Zealand, from England, so I just appreciate that you all take time out of your days to come hang out with me and talk about Vallow Daybell. I think we'll take a couple more questions if there are, and then we'll wrap up for the night. I like to keep it at about an hour because I know that a lot of you want to go over and catch Lauren and John at Hidden True Crime. So if there are any other questions, have you speculated on the reasons why Lori's mental health regressed this last time? Oh, absolutely. And I am pretty sure that what lawyers do is filings come in, and they then trundle down to the jail and they sit down with their clients and they go through all the documents. So when John Pryor filed his motion to sever the case and talked about how his theory of the case was that the crimes were committed by Lori and her brother Alex, and that Chad was an innocent bystander and was kind of an innocent dupe who was totally enamored with this gorgeous woman. I think that when Lori read those things in that motion, that was enough to tip her over. Every indication we have is that she still absolutely believes that she and Chad are the chosen to lead the 144,000, and that this period of being incarcerated and being is just a momentary blip, and that at some point the earthquake will break down the prison walls the way it did for the Apostle Paul, and they'll be on their way to rescue the 144,000. I think she really still believes that. So I think that was enough to tip her over, to know that Chad was not as deeply committed to that as she was. If you lie, do you lose immunity? You can. That's really up to the prosecutor and how egregious your lie is. But that is always the threat, is that if you don't go testify honestly, and you don't go and you aren't truthful, then they can revoke your immunity agreement and prosecute you. Yeah, that's the stick that goes along with the carrot. I want to thank everybody tonight who did super chats. This is our first experience with super chats. I just want to remind everybody that that goes to our moderators, to thank them for taking time out of their day to ride herd on the questions, and so thanks so much for all of you who donated. I'm writing a book, and I'm trusting that my book is going to be successful. This was not a forum for me to raise funds, but I do appreciate that when you all donate, then I can make sure that maybe our moderators get a nice dinner out. Could Chad have given rights to a story in exchange for services rendered? No, he can't. It's anything of value being given for his story. So that's a good question, though. Yeah, he couldn't say, you can have my story if you pay off all of my expert bills, or you pay off my lawyer, or yeah. So yeah, it's Idaho's law is pretty tight about it. Some of them are a little more loose, I think, but Idaho's is pretty specific. So, well, thanks so much tonight for being with us. I appreciate every time y'all join us. 493 people in the chat tonight, so thanks so much. I look forward to reading all your comments, and we will reconvene here next Friday and every Friday at 6 Pacific for a little chat about all things Vallow and Daybell, and an occasional mention of other questions too. So I'm going to say good night, and thank you so much for being with us.